There you are. Yes, Mr. Sarwark, you had your hand up?
Oh, it was just I couldn't unmute myself. That was it.
Yeah, my apologies. I got to have everybody muted for the moment just to get going.
Oh yeah, go ahead and mute me back. I just wanted to make sure the flag was raised that I can't unmute myself if you want to hear from me.
Gotcha. All righty. Well, it is 4:06. We do have a quorum of the JC here, so we're going to start momentarily. This hearing is going to be recorded, and we are going to start that recording right now.
This meeting is being recorded.
All righty. This hearing for the Judicial Committee of the Libertarian Party is now in session. It is 4:07 Central, 5:07 Eastern, etc. We have present 6 of the 7 members of the Judicial Committee, myself as Chair Pro Tem, Mr. Seebeck, Mr. Krawchuk, Mr. Tarnoff, Mr. Latham, Mr. Stratton, and Mr. Montoni, and Mr. Kinsella is currently not here yet. An agenda was put out. We will have, I'll go over it real fast. We will have a period of opening arguments, 10 minutes each for first the opponent and then for the respondent, followed by questioning by the opponent by the Judicial Committee and similar to the respondent, followed by 5 minutes rebuttal by each appellant and respondent, 10 minutes of closing arguments by appellant and respondent, and then we shall adjourn. We do have a timekeeper. We'll be keeping time. That will be having the clock running for answers, but not for questions. We will do our best to make sure that the timing is as equal as possible. We do not have public comment, and as you've seen, chat is disabled. And we will not have any cross-questioning of the appellants and respondents by each other. It will just be by the committee. Look, Mr. Kinsella is in the waiting room. One more, please. Get everybody in here. Mr. Tarnoff.
I was just going to say that I spoke to Mr. Kinsella, but I see he's here now. So,
yeah, he's here. All righty. At this point, we will begin with the opening statement. As soon as I find Mr. Sarwark's name in the list, I will unmute him. There we go. Mr. Sarwark, proceed for the opening arguments.
First, thank you to the Judicial Committee, to everyone who's watching, but mostly the Judicial Committee for hearing this appeal. Our internal processes for dealing with challenges are always superior to our external ones. I want to make it clear from the beginning that we are here because something has happened that has never happened in the history of the Libertarian Party. The Libertarian National Committee has a duty under the bylaws to provide full support for the presidential nominee. In the entire history of the Libertarian Party, over 5 decades, 2024 is the first time that a member of the LNC has suggested or told another member of the LNC to not do something to support our nominee. I have personal experience of having been national chair, been on a cruise out of the country, and rushed to a post office in Puerto Rico in order to make sure that our nomination certificates got to a Secretary of State that had a deadline that was particularly early. But it was common practice for all of those nomination certificates that had not been subject to some special deadline, that they were all signed by the chair and by the secretary as the officers who recorded those nominations, and they were submitted as soon as possible, because the purpose of the party in Article 2, one of them is to nominate candidates and support those candidates for public office. That is why the Libertarian Party exists. There are many other organizations that exist for other purposes, but ours is to be an independent political party and to run candidates for public office. This is not the first time that Karen Ann Harlos has been removed from the Libertarian National Committee. And there are lots of reasons that one could remove a member of the LNC under the bylaws. This is not an appeal of her removal. Dr. Phillies submitted an appeal as the decisions of the LNC in October 6th, 2024, when they took a vote to proceed on the charges from the investigatory committee. Those decisions were in fact a violation of the bylaws. The bylaws require that every member of the LNC provide full support for the party's nominee for president. That duty applies to every single LNC member individually. It is not a duty that is given to the chair and then delegated out to other members. And it is not a duty that goes away if another member of the LNC does not fulfill it. Each LNC member has a duty to fulfill the bylaws, the reason that the party exists. It is alleged that the chair told the secretary not to submit the nomination paperwork to the Colorado Secretary of State at the time that she was going to do it, that the chair gave her an order, and one of the specifications that was presented in the October 6th meeting was that Ms. Harlos had violated that order, had failed to comply with those duties, and that was a type of disobedience that justified removal from the LNC. The problem is that that order itself is a violation of the bylaws. Full support for the party's nominee is full support for the party's nominee. Delaying the submission of paperwork that is normally sent to a Secretary of State in order to benefit a candidate from another party, in order to delay in a way that would benefit a candidate from another party, in order to support a state party affiliate's violation of the bylaws in attempting to submit a different candidate to the Secretary of State than the one that was nominated at the National Convention. All of those things are direct and blatant violations of the black letter bylaw requirement to provide full support for the party's nominee. It is impossible for it to be a proper cause to vote to remove a member of the LNC for doing the duties that were required by the bylaws. Obeying an illegal order would be the violation. Disobeying an illegal order is fulfilling the duty of the bylaws. It's the one thing that you can't remove somebody for doing her job. The party has a purpose. The purpose is to run candidates for public office. Our candidate for president was nominated by the delegation at convention. The secretary submitted the nomination paperwork as was required by both the law and by the bylaws of the party. The secretary is not a subservient officer to any other officer. The chair can assign duties to a secretary, but the secretary has independent duties and an independent duty to follow the bylaws. The other issue that is very important to point out, and a reason that the other decisions of that October 6th meeting are also violations of the bylaws, has to do with the fact that all of the report, the investigation, the hearings about Ms. Harlos were conducted in executive session or secret session, which violates the requirement in Article 7, Section 15 of the bylaws that all votes and actions of the LNC must be in open session. The only exceptions are listed later in that bylaw, and they include things like personnel matters. But Karen Ann Harlos is neither an employee or a personnel. She is not in the common knowledge or a common meaning. She doesn't work for the LNC. She has an officer position on the board, but she's not personnel. And neither myself nor any previous chair that I'm aware of, and I've talked to at least 6 of them, would have ever considered personnel to be a volunteer, not a volunteer, rather, volunteer can be personnel, but a person who is a member of the LNC cannot be personnel. They are a different thing entirely. And any kind of allegation of malfeasance, any allegation of wrong actions that justify a removal have to be presented in open session. Otherwise, it's impossible for the other members of the party to know whether or not the decisions are justified. It's impossible to review decisions that are secret. That's why when decisions are made that are in violation of the rules, they're often done in secret. Because if there's a record, if there is something that can be shown as evidence that is contrary to the allegation, then there's the possibility for a defense. But if there is secrecy, there's not the possibility for anybody to review the decision. What this comes down to is very simple. Our party was established in order to run candidates for public office. We have nominated a presidential candidate in every single presidential election since 1972. In every election prior to this one, the LNC has been foursquare behind our candidate, even if some members of the LNC did not think that it was strategically wise to choose the candidate. They did not go so far as to suggest that an LNC member should do something contrary to the full support for the party's nominee for president. The vote to remove somebody cannot stand under the bylaws if the reasoning for removing them comes from something that is in violation of the bylaws. If you are the CEO of a company and that company sells cars, for example, just to use a weird one, and somebody tells you, and the bylaws of the company, the corporate organizing rules say we sell cars. Telling an employee to not sell cars, a board member saying don't sell cars, stop selling cars, is directly contrary to the purposes. You cannot follow that order and still be consistent with your own duties. And so I would ask that the Judicial Committee see this for what it is. It is an attempt to remove somebody who is a troublemaker, who is difficult on the board, who has been removed before, and who is generally a pain in everyone's ass. But it's not done in the right way. It is done because she was following the bylaws and while the chair was telling her not to. With that, thank you.
Thank you, Mr. Sarwark. One moment, please. We have to reset our timer. All righty. Ms. McArdle?
Thank you. I'm going to speak for a minute and then I'm going to turn over the rest of my time to Jonathan Jacobs, the parliamentarian who's been assisting us. The decisions and actions of the LNC that are the subject of this JC appeal were carried out correctly under the scope of the LNC's bylaws and Robert's Rules of Order. Furthermore, while the appellant has the right to appeal decisions of the LNC, this decision is no longer pending, and all of the motions have essentially been dispensed with. None of the LNC's motions from the October meeting have continuing force and effect. The adjourned meeting already happened. The trial happened. The pretrial suspension ended with the disposal of the case. Mr. McGee finished serving as trial manager. He is no longer the trial manager. Furthermore, only an officer can appeal his or her suspension pursuant to bylaws 6.7. This was a procedurally correct removal. The removal procedure is governed by bylaws 6.7 and maybe 7.15 to a certain extent. Policy Manual section 101.4 and Robert's Rules of Order section 63. That is what we followed. We adopted resolution language straight out of Robert's Rules of Order in section 63, 13 through 20. The duties of the secretary are very clear. The bylaws say the secretary shall be the recording officer of the party and shall perform such duties as are assigned by the chair or the national committee. The secretary shall attend all meetings of the national committee and all party conventions and shall act as secretary thereof, keeping such minutes and records as necessary. Minutes, keeping records, performing duties that are assigned by me or the national committee, that's it. I instructed the secretary to hold off and not submit anything yet until I had a chance to work it out with Colorado. Things were certainly in process. It was heated. It was ugly and uncomfortable. They did have a meeting that I arranged. I sat in on the first half of it. The Montana LP by the way, passed a similar resolution to Colorado's, I was able to work with them and get Chase back on the ballot. There was no bylaws violation baked into my instructions, not a single place. In fact, it was an instruction mandated by the bylaws. I deliberately disobeyed it and instructed another LNC member to keep it from me. And she later bragged that she would absolutely do it again. Mr. Philly's argument that delaying the submission of nominations papers is a bylaws violation is completely made up and characterizes the actual events that took place. Professional behavior and diplomacy may be out of character sometimes for libertarians, but they are not bylaws violations. And that's what I was using to make this happen so that people didn't send cease and desist letters back and forth, end up suing each other, and so on and so forth. The point of this charade was not to support our presidential ticket or prevent a gross injustice from being done. By charade, I mean this JC appeal and everything that's been attached to it. The whole situation of Ms. Harlow's action, it was spun up to create a public spectacle of hero worship and martyrdom, which she was successful at. In the process, she's caused further financial hardship for us, sued us, taken us away from working towards the stated goals of this party, taken us away from candidate support, and turned the JC into her own personal circus. Mr. Sarwark's arguments are a red herring. Again, I'll say, he has, our candidates did receive full support from us. None of the instructions that Mr. Phillies are appealing have anything to do with full support not happening. It's interesting because in the past, the LNC has put out all sorts of resolutions condemning the statements of certain presidential candidates, in particular, Gary Johnson. Not a single thing like that came out of the LNC. I instructed our social media team, staff, and everyone else to white knuckle it through. No official statements about anything our presidential candidate said that you do not like. The bylaws are clear about the duties of the chair and the secretary. The JC has been provided with a full copy of the IC report so they can understand the nature of arguments about executive session and personnel. We trust the JC will keep that report confidential. That's all I have for you. I'll turn it over to Mr. Jacobs.
Okay, good evening, and can you all hear me? Thank you for permitting me to appear. I want to start out by saying something kind of direct here. Dr. Phillies is asking you to violate your bylaws. Under Article 6.7 of the bylaws, it is up to the Libertarian Committee to suspend a candidate and possibly remove one. There is this process. It is not an appeal that can be taken by a group of members to the JC. On the meeting of October 6th, there was, first of all, no action taken in executive session. And second of all, there was no action taken to remove. It was the beginning of the process to remove. That's all that happened. When Dr. Phillies filed this appeal, neither he nor, frankly, I knew if Karen Ann Harlos was going to be removed or if she was going to be otherwise punished or if she was going to be found guilty or not. She has the right to appeal, and that right should remain unfettered, and it should be hers, not the right of the JC at this point. They will get to hear the case. Let's see if I can go on just a little bit more on this. I think a lot of it has been covered, though. There would be one additional point, and that is this also violates the will of the delegates at the convention. They determined in 2022 that under the bylaws to remove somebody, the due process is required. This was the start of that due process at the October 6th meeting. What happened after that is subject to appeal, but this is not the place for it. And when Dr. Phillies filed this appeal, this was not decided. Everything that he has asked for to be appealed has already has already taken place. Their emotions are no longer in effect. There will be an appeal by Ms. Harlos. She is entitled to that. I strongly respect her right not only to that appeal, but her right to make her own arguments. I may disagree with them. I do disagree with some of them. But she has the right to make them herself. That is all that I have. Thank you.
Beg pardon, I was muted for a moment. Ms. McArdle, you still have 3 minutes left on your opening arguments period. Do you wish to have any more statements? Ms. McArdle?
No, I cede my time. Thank you.
At this point, we will proceed to the questioning by the committee. The first, pardon me there, the first set of questions will be directed towards the appellant. Before this hearing was drawn up on the agenda, we took a random draw of the order of the questioners for the JSP. So for questions for the appellant, we begin with Mr. Stratton. And I'm going to unmute Mr. Phillies and Mr. Sarwark, and I'm going to unmute Mr. Stratton as soon as I find them. So please bear with me for one moment. Mr. Sarwark, Mr. Phillies, and Mr. Stratton. Mr. Stratton, go ahead. Here. Mr. Stratton is still on mute. Hang on.
Here we go, right there. And this is questions for Mr. Sarwark?
I think so.
Okay. So, Mr. Sarwark, your allegation is that being told to delay, or what you're stating is being told to delay is the same as not supporting the candidate?
The requirement of the bylaws is full support for the nominee. It's not just mere support, right? If it just said support, then it would be potentially something different. But full support of the nominee means that all the things that basically the committee has to do things to support the nominee,
right?
And nothing to impede the nominee, right? It's impeding the nominee that brings it back from full support.
Okay,
right?
so and what
or
you're
choosing
saying,
not to do things that need to be done.
Okay, so what you're saying is a delay would equate to not having full support.
It both equates to not having full support, but as a factual matter in this case, very specific to the Colorado matter, the Colorado party was intending to put on RFK Jr. onto the ballot and was trying to get enough time to be able to do that prior to the joint fundraising committee being launched. And Ms. Harlos sending the nomination paperwork in made that impossible, right? The Secretary of State could not take an RFK nomination after they had taken a Chase Oliver nomination. But the intent, the reason for the delay, while it has been characterized by the current chair as being to smooth things over and help Chase Oliver, the actual intent was to impede Chase Oliver from getting on the ballot as quickly as he could to get momentum coming out of the convention, right? Delaying the nomination papers getting sent to the Secretary of State beyond any normal mail delays has the effect of taking away early campaign momentum, the convention boost, as it were. In years past, both in 2016 and 2020, both of which I'm very familiar with from personal knowledge, we got those certificates in as quickly as they could go. And there was never any question about delaying anything other than maybe we were missing a signature from a candidate and had to overnight something.
All right. Thank you, Mr. Sarwark. I had one other quick question.
Go right ahead.
The Colorado, from what I was reading the form, it says basically what the national chooses as the president, right? From the Colorado's SOS. That has to be what they need to be listed.
It has to be the choice of the national convention.
Right.
You cannot submit a candidate that was not chosen by the national convention. And had the Colorado party submitted a different name, that would have created a whole big question for the Colorado Secretary of State of whether or not they could take it.
Okay, thank you. No, nothing further.
Mr. Seebeck, is there like a round robin or something?
There is, but I apologize because I had muted myself. Next up is Mr. Montoni.
I have no further questions at this time.
Alrighty, we will next go to Mr. Kinsella as soon as I find him in the list. The long participant list, there it is. Go ahead, Mr. Kinsella.
I actually had not raised my hand, but since you called on me, I'll ask Mr. Sarwark, does the chair have the authority to instruct the secretary to delay sending the certification?
I don't believe that the chair has the authority to do that, absent some sort of fact that, some sort of hypothetical fact that I'm trying to come up with, but I cannot think of a hypothetical in which a chair could tell the secretary to delay submitting ministerial paperwork that reflects what had happened at convention without it being a violation of the full support. I can't think of one. And I'm usually pretty creative about thinking of things chairs can do. You muted yourself again. Sorry, Stefan. Or Mike muted you. I'm not sure.
Sorry. I guess the question is, what is the authority of the chair to give instructions to secretary or other officers about matters like this? Does the chair have any role? Can the chair instruct the secretary to do or not to do something that is within her power?
So I don't think the chair has plenary authority to assign duties to the secretary. So the chair could theoretically assign the secretary to go get her dry cleaning or something. What the chair does not have the ability to do is to impede or take away from the ministerial duties that are inherent to the office itself, right? The secretary is the person who signs that form and submits it and attests to the fact that it was the vote of the convention to nominate Chase Oliver and Mike Termott. She is the only person that can do that duty. It is a duty that is required by the bylaws and under her recording power, or the second half of her clause. And I do not believe that a chair can, consistent with the bylaws, impede or issue a duty to hold off on doing a ministerial function. I can't think of a reason or a justification for it.
Okay, one more question. You said it's the secretary's duty and obligation. What if the situation were reversed and there was a secretary who refused to fulfill this role, and the chair just did it herself?
One, a secretary refusing to fulfill this particular role would be absolutely grounds for removal because it's a direct violation of the bylaws. Two, the chair could do the job of the secretary for the secretary if it was necessary or needful to get that nomination paperwork in. Basically, someone else can help you do the thing you have to do, but it is not consistent with the bylaws to order you to slow down, slow roll, delay, impede, or in any way stop you from doing the thing that is full support.
And what if in a bizarre situation, if we said, hold off for a week or two until we can sort this thing out before we do this, and the chair told the secretary not to do this for a week or two, but we will do it in time when we have to make the decision? What about such an instruction? Could that be disregarded by the secretary or not?
Yes, but I appreciate that question because it brings up a point that I failed to make in my opening statement. That one of the justifications for this request for delay has been purported to be that the Colorado party was really mad and might file suit, might disaffiliate, might do something bad, right? There would be bad outcomes if it was submitted prior to them being smoothed over, as Ms. McArdle characterized it. The fact of the matter is that we deal with litigation literally every election cycle. I think we were in, 4 or 5 different courts in 2020. We were in various ones in 2016. There's always the possibility that somebody will complain or kick up the fuss, or there'll be controversy. But avoiding the controversy of submitting an uncontested, valid nomination to a Secretary of State, that isn't a valid reason for the delay. If there was, for example, an error in the form, right, it listed someone that the convention had not nominated, that would be, I think we found the one hypothetical. That would be the time when a chair could say, do not submit the erroneous form, because the erroneous form would not be providing full support for the nominee.
Thank you.
Mr. Cassell, you muted yourself again for a second.
Yep. Thank you. Thank you. Thank you. I'm done.
All righty, next up is Mr. Latham.
I'm going to put this to both. I don't know if we're doing both.
I think you have to do seriatatum.
Uh-oh, what did I do? I missed some Latin there.
No, you have to ask me and then I answer. And then when it's the round for the other side, then you have to ask the same question. So you got to remember to ask it twice.
Unless you meant to ask me.
Okay, I'll make that mental note here. So recognizing that we can't prove the counterfactual, I'm just wondering if it's possible to read full support in the context of submitting nomination certificates to election officials corresponding, let's say, to each dissenting affiliate. And it sounds like maybe in this election cycle, we had around a dozen. That doing at the time that Ms. Harlos did with Colorado would have ultimately turned out to be counterproductive. In other words, the party's national ticket would have ended up on fewer ballots than the ones we did end up on. And just to elaborate on that question a little more, if we're measuring support, would not the number of ballots on which our national ticket appeared be one way to measure the fulsomeness, since we're using the full word, of that support? So that's my first question.
The number of ballots that we get on doesn't measure the full support because that's a government function. That's not a party function, right? So if certain states don't put our candidate on the ballot, that is just the uphill battle that we fight. And there's a sort of an unsupported term in your question, this idea of a dissenting affiliate. Affiliates can dissent in advance of the national convention. They can, after the national convention, be very upset that the national convention chose the wrong candidate. But there is no such thing after a nomination as a, quote, dissenting affiliate that has any type of right, because the affiliate has a separate and very plain bylaws duty to do nothing other than submit the candidate that the national committee put in. So there is no, this is the problem with this idea of reconciliation or smoothing over. You smooth over misunderstandings, you smooth over hurt feelings. But if the national committee chose a presidential candidate that your state party doesn't like, that is a problem that you'll have to deal with. And I don't see any situation in which your counterfactual would go forward where failure to delay would result in fewer ballots. Because the ballot, being on the ballot is related to the actual government official putting the candidate on. It's not related to whether or not the party won. The state affiliate, I should say, to use the correct term.
Let me jump in there. I tried to jump in earlier. Apparently, once I mute myself, I cannot unmute myself.
Yes, just stay unmuted. We're all polite here.
All right. Okay, but when you acknowledge that, you say, okay, state, or sorry, you're talking about we can't control what government entities do, but we may have a little more influence as a national party over what affiliates do. And so I think, again, my counterfactual here is, can't there have been a calculus by the National Committee saying that if we kind of hold off and let, if you look at page 6 and 7 of the party's response brief, where they say we just wanted to let some time go for people to vent, let some steam blow off, and then we would have ended up with net higher number of affiliates that were, willing to put our candidate on their ballots, rather than have to kind of fight through that objection. So again, do you see what I'm saying? That it's not that the LNC is, worried about what government entities are going to do. They're worried about what affiliates might do, and that might end up being that'll inhibit their ability to provide the greatest amount of support they would like to have. Do you see my point there?
I'm aware of what the LNC has said in their brief, and this allegation that letting off steam or a cooling off period would increase the likelihood that the candidate would be on the ballot. It's absurd on its face. It doesn't mesh with reality. What was in fact happening was the delay was an attempt to let the Colorado Party and other dissenting parties get their ducks in a row to try and submit a rogue candidate nomination form. And the secretary moved faster than that. And it kind of messed up a whole bunch of people's plans. And they're very upset about it. And this is the end result.
And I'm looking for this. Maybe I'll come back to it. I will say a question I have. You say that it's a duty of the secretary to submit nomination paperwork. I will say I see the word sign. I'm not seeing the word submit. So if people can point me or us to that, I'd be interested in seeing that.
The word's not there. It's implied by full support. Right. The paperwork has to be signed in by the appropriate people, and then it gets submitted in. The party has to make all attempts to, as soon as possible and without delay, put the nominee of the national convention on the ballot. That is the requirement of the bylaws. Justice delayed is justice denied. And similarly, any delay in a political campaign, especially a presidential campaign with a very fractious nomination period, it is fatal. It is fatal. And the results have shown it. The delay and the uncertainty in the time after the convention have correlated with a historically low performance by the presidential ticket. The proof is in the pudding.
Okay. Let me jump to another quick one. Do we know why Ms. Harlos did not appeal the temporary suspension on October 6th?
I have no idea why Karen Ann Harlos does anything Karen Ann Harlos does. I mean, that's why I wanted to make it very clear at the outset. I am here to make the arguments on behalf of Dr. Phillies for the bylaws issue of the vote. I am not here for Karen Ann Harlos.
Okay, but this, I think, goes to the LNC's position on one that appealing officer suspensions, and we've been using suspension of duties versus removal from office or suspension from office, and those both might be covered in Article 6.7. And so again, I think we're just trying to parse that out, whether that's exclusive to the suspended officer, or can members white knight that issue. So
I'll provide what I think is the truth on this, but I'm not sure it's necessarily germane to this appeal. I don't think the temporary relieving of duties is in fact compliant with our bylaws. I think that Roberts in that case is in conflict with the bylaws, because the bylaws provide for a suspension or not a suspension. I don't think you can pull somebody's card while you figure it out. I don't think that's proper or allowed under our bylaws. But the fact that Karen Ann Harlos chose not to appeal that procedural issue at the time that she was temporarily relieved, I don't know. I mean, maybe it's a strategy thing for.
Okay.
I can't speculate.
Let me jump to there's a litigation exception to this open meetings language, right? And you say, well, she's not an employee. I that seems sensible.
Not personnel, yeah.
But there's a litigation exception, and why doesn't that? If at the time of both hearings, if I'm correct, I think Ms. Harlos had initiated litigation against Ms. McArdle in her capacity as chair of the LNC. So if that's true, why does not that litigation qualify as the exception to the open meetings rule?
Oh, because the suspension isn't about the litigation, right? The issue here was claimed to be the litigation potential of submitting something that the Colorado party would then sue over. But potential litigation is not litigation, and after the thing has been done, it's not the appropriate time to discuss the strategy about the thing that never happened. The fact that Ms. Harlos, as an officer of the LNC, filed a derivative action against Ms. McArdle, I understand why Ms. McArdle would be upset with Ms. Harlos. That makes sense. And that is litigation. But this October 6th meeting, the investigation of her, that isn't discussing a strategy for defending the derivative suit. I believe that both of the LNC members who have brought derivative actions have been rightfully excluded from discussions of the derivative litigation that have occurred while they are still on the board. So it is proper to exclude somebody from litigation in which they're a counterparty, clearly.
Oh,
clearly.
Okay. Well, and you mentioned potential litigation, which I think is also in that description. There are supposedly threats of defamation actions. Doesn't that qualify? This is separate from Colorado ballot status. Would that not qualify for an exception to the open meetings rule?
No, I don't think so, because threats of litigation, right? I'm going to sue you for defamation. Not only are they part and parcel of just being in the world these days, everyone threatens to sue everybody for slander and libel, and it's never really meritorious. But until there is actual litigation, until there is a question of how do we respond to the actual litigation, right? There is no indication here. There's been no claim here. There's nothing that we are on notice of that the reason for holding everything in secret where the members can't know what the allegations are is because of litigation strategy. And even if there was such an argument, you have to constrain the executive session to that topic. And I have led executive sessions on the LNC repeatedly. And as soon as the comments inside that executive session stray from the very narrow purpose for going in, someone, usually myself, but often another member of the LNC, will say, we are now moving on to things that are not properly in executive session, and we need to rise out of it. This was not a partial executive session. All of the proceedings, all were in executive session. And the requirement of the bylaws is that the National Committee and all of its committees shall conduct all votes and actions in open session. So not just the votes at the end, the actual debate over what to do also has to be an open session, and that was violated in this case.
Okay, thank you. One more, and maybe you saw Mr. Jacobs' amicus in this matter on the standard for suspension or removal, arguing that the bylaws is the policy manual standard of failure to perform duties or gross malfeasance violates the bylaws, which just has the for cause standard. So I just wonder if you can speak to that. Does the policy manual standard violate the bylaws? And can the LNC basically carve out a more narrow standard for officers than what's in the bylaws?
I believe that the policy manual can narrow cause, but the policy manual can't expand it. In the same way that a state constitution can provide greater rights than the Bill of Rights under the federal constitution, but may not abridge any of those other rights. So while the bylaws still are written with the very broad language of cause, meaning you don't like her is enough of a reason, the policy manual narrowing that down to a tighter set of things that are easier for review, that seems like a greater protection, not a lesser protection. And so I don't think that's in conflict with the bylaws. I'm not sure. I'm not sure that. Oftentimes I see arguments that somehow subsidiary document, either Roberts or the policy manual, can somehow supersede the bylaws. That cannot be, and that's absolutely backwards. But in this case, saying as a matter of policy, we don't remove somebody for causes other than this gross malfeasance standard, that is essentially prosecutorial discretion, in the same way that even though there are valid criminal cases against the president, the Justice Department has a policy manual that says we don't prosecute sitting presidents.
Okay.
It's a constraining, floor not ceiling.
Okay, but you're a criminal defense lawyer. I'm a criminal defense lawyer. If we see a prosecuting agency use a blanket policy saying we are not going to plead on violent crimes, are you aware? We can challenge that. That's basically saying you're violating due process because you're taking away your discretion.
I guess you can make the argument, but it would be a prosecutor that would be making the argument, right?
Why would it be the defense attorney saying you are taking away your discretion, and by doing that, you're failing to treat my client as an individual rather than a member of a class?
Maybe, but I don't think it applies here. I don't think that if the entire LNC, the body that under the bylaws could remove her for any cause, constrains themselves by the policy manual to say they're not going to remove her for any cause, they're only going to remove for gross malfeasance, then I believe that the LNC is constrained itself. And it would be similar to an elected prosecutor saying, as a general matter, our office does not file on low-level drug crimes, right? You can say that we don't do it and that we have generally a policy of exercising our discretion in a particular way. And I don't think it's a due process violation to constrain yourself. I don't see it.
Well, you said the policy manual can narrow the standard, but it can't expand it. So, for example, I'll use a less inflammatory hypothetical than I've been using in our committee chat. How about we change the language to no party officer or at-large member from an affiliate with more than 10 members, let's say 10 delegates, shall be subject to removal, right? So the idea is that larger affiliates get a break that the smaller number of affiliates don't get. So you're saying the LNC can narrow it in that fashion, and that's okay?
No, that would be a due process violation for sure.
Okay.
The specific policy manual narrowing that they've done, and it being the LNC that provided that narrowing to themselves, is to say that we are not going to use causes other than this enumerated list. So that is limiting how many things they do, but it fits inside of cause, which is the broader ambit of the bylaws. So that policy manual restriction doesn't. If the LNC did a policy manual thing and said, we will remove an officer for cause or gross malfeasance, but not if her last name is McArdle, that would in fact violate the bylaws, because then the rules would not be applied equally across everyone.
Okay. Mr. Chairman, that is all I have for this round. Thank you.
All right, thank you, Mr. Latham. We move on to Mr. Colonel.
Okay, hello. Is there an executive committee? Can anybody answer that? And who comprises it?
There is an executive committee. It is comprised of the officers and 3 members chosen by the LNC.
And now my understanding is that the chair seemed to be saying there's an overall strategy, and Karen Ann Harlos, Ms. Harlos, jumped the gun on it. Was that strategy the official policy of the executive committee?
I don't know what you mean by a strategy.
Well, Colorado Secretary of State needed an official document signed by the secretary or the chair, and Ms. Harlos went ahead and filed it contrary to the directives of the chair. Is that correct?
That was at the outset, yeah.
And I want to know, Ms. McArdle, I understand, said that that there was a plan involved to work this out with the Colorado Party, and that Ms. Harlos sort of jumped the gun, right? And went ahead, and it kind of disturbed the delicate negotiations between National and the Colorado Party. Have I got that right?
That is what she's claiming.
So what I'm asking is, was this a policy of the executive committee, or was this just a policy of Ms. McArdle?
I have no idea.
Let me point out that the charge says that it was done by McArdle. Also, with respect to the Reconciliation Committee and what it may or may not have done, I specifically asked the JC chair to procure a copy of this Reconciliation Committee records so that I could see what was going on and what it meant in terms of the claims of the national chair. I have not received such records, and therefore claims that the Reconciliation Committee did something are open to question.
Okay, another question. Mr. Sarwark, did you imply earlier that it was Ms. Harlow's intent to harm the Oliver campaign?
I don't think I implied that it was Ms. Harlos's intent to harm the Oliver campaign. I did say
that it was to protect the Oliver campaign from the Kennedy campaign. Nick, you're...
Yeah, sorry. I was trying to turn my video back on. I went to get a little more water. I believe what I said earlier was that this delay was to be of benefit to the Kennedy campaign. So it wasn't necessarily that it was to hurt Oliver directly, but to benefit somebody other than the candidate of the party, a candidate from a rival party.
Was that alleged in any of the charges?
Was
this intent, the intent to
by Ms.
help?
McArdle? Ms. McArdle is not here on trial. Right, Ms. McArdle wasn't attempted to be removed. We're only talking about what Ms. Harlos...
Was it alleged that Ms. Harlos' intent was to help a foreign campaign against, who's in competition with our own candidates?
No, what we're saying is that Ms. Harlos submitted the paperwork required by the bylaws for full support of Chase Oliver, and that Ms. McArdle wanted to delay that paperwork to benefit someone other than Chase Oliver.
I see, Ms. McArdle. Right. I'm sorry. Okay. All right. I think you. All right. I think that's all the questions I have for your side. Thank you.
Thank you.
All righty. Next up is myself. I will
I think Kinsella
my
had
first-
raised his hand, but I'm not sure if you guys do like multiple rounds.
We're not slated to now.
Okay.
So I will ask my third question. The bylaws specifically say in Article 6, Section 7, and its companion for the at-large members, a different article, about suspension for cause. The policy manual specifically says suspension for malfeasance. For cause is defined in Roberts to include misconduct. What is the difference? And you already elaborate on this a little bit in your opening statements, but can you elaborate further on what is the difference between the three standards in terms of both what they mean and what kind of hierarchy they have?
You said three standards, but can you, I know that you've got for cause in the bylaws. You have gross malfeasance in the policy manual, and Roberts is misconduct. Is that right?
Roberts defines misconduct as being part of for cause, yes.
Yes. Okay. So for cause as a legal term of art is basically, I've got a reason, right? So the only thing that doesn't rise to the level of cause is a nonsense reason. This, for example, doesn't rise to that level. Gross malfeasance requires that it's not just you did something bad that is a reason I want to get rid of you, but that it has to be significantly above and beyond general garden variety bad stuff. It's got to be you really tried to do something to harm either the organization or harm the purposes. The gross malfeasance standard is a tighter standard, right? Gross malfeasance is one type of cause, one type of misconduct. And so I think, does that answer the difference? Basically, you know, which is the Venn diagram of which is bigger and which is smaller, or is there a different question you're asking?
No, I believe that answers it. Second question. The policy manual specifically allows for suspension from duty, rights, membership rights and duties. And the resolution in question also said that type of a suspension until disposition of the trial. Does Article 6, Section 7 on its definition of suspension, with its failure by if the suspendee fails to appeal, doesn't that put that LLC member in the position of a failure to appeal a suspension from duty becoming a removal? And does that make any sense?
So it doesn't make any sense, but part of it has to do with the fact that the bylaws were not necessarily written by lawyers, and the word suspension is not necessarily a very good word because it has multiple meanings. In the bylaws, it has traditionally meant it is the removal, right? You've taken that officer off the committee. So suspension is basically the same as removal under our bylaws historically. What Roberts and the policy manual allow for is this type of temporary suspension that is not a removal from the office and doesn't trigger the due process provisions of Article 6, Section 7. That's why I think that policy manual provision is in fact a violation of the bylaws, because there's a due process right for the officer to appeal, but it only is triggered when the officer is actually permanently removed, the meaning of suspension in the bylaws. And so the result is that there's this limbo of due process in which someone is silenced, someone is unable to do the duties of their office. They are, for many purposes, no longer able to be on the committee, but for the purpose of stopping them from having the timeline start for the Article 6, Section 7 rights, they are not suspended, because at the end, maybe she might not actually get removed, as Mr. Jacobs claimed in his initial opening statement. It's a possibility. You know, lots of things can happen. But the result is you get to silence somebody without any due process rights for a while.
All right. Let's change it up a little bit here. If Mr. Rios had not filed the paperwork and followed the instructions of the chair to not do so, and as a result of that, the LPCO would have put Mr. Kennedy and Ms. Shanahan on the ballot, which has some questionable legality for other reasons. Let's say they did that. Wouldn't that put Ms. Harlos in a position of being forced to violate the bylaws? And wouldn't that also be violating a section of Roberts that requires the chair to handle business in an expeditious manner?
It would. Basically, at that point, both the national ticket, as a matter of right, and other members, as a matter of right, would be able to challenge or seek the removal, seek the reversal of the decision, seek some sort of sanction for both the chair who ordered the paperwork to be delayed, as well as the secretary who carried out the illegal order.
Forgive the personal aspect of this question, but were you in the party back in 2000?
I was. I think my membership card says 98 or 99.
I asked that to set the table for the next one. Do you have a recollection of what happened with Arizona in 2000 regarding the presidential race nomination?
I do, and I studied the history of it afterwards because it's very it's helpful to see what's happened before when other state parties do things that are separate from what the national party wants to do.
I also do, and it's covered in my book, Funding Liberty, in great detail.
Well, for purposes of the moment, could you elaborate on what happened then?
Go ahead, Dr. Phillies. You know the facts well too, if you'd like.
The LNC had to decide who the state party was. They made a decision. This is before the National Convention. They decided on the group that did not have control of the ballot to put a presidential candidate on the ballot. At the convention, both groups showed up in some number, and the people from the Phoenix group that had been denied affiliation had to work to get on the floor. We nominated a candidate. The Arizona group that controlled the ballot access took the position that since they'd not been allowed to be represented in the National Convention, they would make their own decision as to who the nominee should be. But they invited our then candidate to show up in Arizona and convince them that he should be put on the ballot by them too. He chose not to do that, and they eventually ran L. Neil Smith. Thank you.
And what happened to the Arizona party as a result of that?
There was years of recrimination and backlash, and I think it took, oh my gosh, it was like 3 or 4 years before everything settled.
There was also litigation, and in the end, the group that the LNC had recognized was found by the courts to have elected, I think ward and precinct, something like that, county members, and therefore was the legal party. And at this point, the Phoenix group that had run L. Neil Smith decided to dissolve and did so.
So that result of all that after at the time in 2000, then I believe it was Harry Brown was the candidate. Did he wind up on the ballot for Arizona?
Harry Brown was not on the ballot in 2000. That's why every time we say that we had 50 state plus DC access in the 2000 election, there's a little asterisk that says you have to phrase it as a Libertarian candidate was on the ballot in all 50 states.
Forgive me, that was right by the time I joined the party. That's why I asked the question. Was there any, okay, so you said that the opposite group dissolved, that's fine. Is there a parallel between what happened there and what's happening with the Colorado situation for this election? Would you say?
I think there are some parallels, with the primary difference, as Dr. Phillies remembered and I had forgotten about, that the dissident parties in the 2024 election, the state delegations that felt that they wanted somebody other than Chase Oliver to be the nominee, had the opportunity to vote and be heard on the convention floor. And there were many rounds of very spirited balloting for the presidential nomination this time. The big problem that the Arizona party had was the due process violation, that the national committee had basically said, hey, this party that actually can put our candidate on the ballot, we're going to disaffiliate them or not allow them to participate in convention. And then when we nominate somebody, we're going to go, hey, now that we kept you out of the room, you didn't have any voice in the process, please put this candidate on that we're shoving down your throat.
Okay, fair enough. I think I have one last question here, and this is kind of straightforward. Was there any failure of duty by Ms. Harlow in filing the paperwork? And I believe you mentioned that in your opening arguments that there wasn't, but is there any authority of Colorado to override the national convention?
There is no authority of Colorado to override the national convention because, and I apologize for not having this particular bylaw in front of me, it is a specific requirement of the affiliate party. It's one of the very few. Article 5, Section 4. No affiliate party shall endorse any candidate who is a member of another party for public office in any partisan election. Like, they just can't do it. And so any attempt to help them do something that they are specifically not allowed to do by the bylaws is itself a violation of the bylaws.
So when Ms. Harlow is doing what she did, that actually protected Colorado from getting sued for violating the bylaws and not putting the wrong candidate on the ballot. Would that be a fair assessment?
That's a fair assessment. There's also the second sentence of that bylaw section. No affiliate party shall take any action inconsistent with either the statement of principles or these bylaws. And so taking an action inconsistent with the duty to provide full support of the nominee would also be a violation. I'm not sure that it would be a legal problem in court, but they are definitely subject to disaffiliation. There's cause for which the LNC could disaffiliate an affiliate party that did that, or even had they made a public statement endorsing Donald Trump, for example, as the Libertarian Party affiliate in New Hampshire has done this election cycle. That is grounds for disaffiliation. Whether or not the LNC will do anything about it is entirely another question.
All right, that's all the questions I had. Thank you both. Now, last questioner for the petitioner, the appellants, is Mr. Krawczyk. Go ahead, sir.
Thank you very much, Mr. Chair Pro Tem. First of all, let me start off by saying, Nick, I believe the first time you and I met was in 2000 at the Virginia Convention when I was running for vice president. So you were in.
I think it was. Was I Maryland chair at the time, or was I not chair yet? Was it after that convention?
I don't know. You're lucky.
We've known each other for a minute.
Yes, been that way. All right. A lot of the questions I had have already been answered, so it's a good thing I got placed last. So, Nick, let me start with you. In your opening statement, you mentioned that the secretary and the chair signed the paperwork to put somebody on the ballot. Was that not the case in Colorado?
The documents were signed.
Who signed the documents?
As far as I know, it was the secretary and the chair. I haven't seen this. I have not seen the certificate of nomination in the 2024 cycle. But as I recall, it depends on the state whether or not the form has just the secretary or also the secretary and the chair. Some states require it, some states don't. I believe in 2016, we had every single form had both signatures, and just in case, but my memory does not serve that well.
All right. When I get to Angela, I will ask her, but from what you're saying, both of them signed it.
I think so. Or I'm not aware that Angela withheld her signature at any point.
Okay. So
I should say that's what I'm confident in claiming. I'm not aware of it.
So
Or
that
with-
signature would have represented approval.
It would have represented that she did her required affirmation that the convention did what they did. Yeah.
Okay. Thank you. Let's see. You already answered that question. Thank you very much. Let's see. And I believe, Nick, that's the last question I have for you, but I have some general questions. I'm not sure who can do this better. What was the deadline for Colorado, and when did it get submitted?
The deadline was sometime later than it was submitted by a period of a month or so. I'm not exactly sure of the deadline, but it was after it was submitted.
So on the order of a month, you're saying?
I believe I don't have those dates in front of me. I apologize. But I believe the deadline in Colorado is sometime in September. So, but I don't remember the actual date that the certificate got sent in.
Ballpark, please. Weeks, months, hours?
Weeks. Weeks, potentially up to a month in advance.
Okay, so there's time.
But it was also well after this national convention had concluded, much later than it had been in years past.
Okay. Thank you. Let me see. I always have difficulty reading my own handwriting. The nuns always smack my hands for this.
And by the way, I mean, I would suggest, not to tell you who to ask, but I think Ms. McArdle would be the one who would know exactly when it's on this here.
I agree. And I did prefix my statement saying I'm not sure who could answer that one. All right, Nick, I believe that's all that I have for you. Let me just say, though, I do enjoy your dry wit. It's good to hear.
Oh, appreciate it.
All right, Ms. McArdle, just let me ask that same question. What was the...
Hold on a second. Mr. Krawchuk, we are going to move on to respond to questions, but we're going back through the list. So I'm asking you to wait for that.
Okay.
So,
apologies.
No worries. All right, we will.
I'm going to mute myself. So if you need me, you can do the unmute thing.
Yep. We will move on now to the respondent. I'm going to pause for a moment here to get everybody straightened out on who's muted and who's not. So bear with me for one moment. Unmuting Ms. McArdle. And Ms. McArdle, who else did you wish to be available for answering questions? Was it Mr. McGee?
Yes, please.
Anybody else?
Mr. Jacobs, if you have a procedural question.
Okay, fair enough. We'll get that there. All right, and with the same thing as before, we will go through the same order, and we will start with Mr. Stratton as soon as I find him on the list. There he is. Mr. Stratton, go ahead.
Ms. McArdle, do you have any way of believing or understanding why Ms. Harlos would think that the National was going to act in interest against the Oliver Chase campaign in Colorado?
No, absolutely not.
And also, is there different forms that Colorado has that would require the secretary and the chair, or some that would just require one or the other?
She did find a different form.
So the state has different forms.
Yes, multiple states have different forms. Some states will accept more than one form. Some states are very particular.
All right. That's all I have for now. Thank you.
Thank you, Mr. Stratton. Mr. Montoni.
No questions at this time.
All right. We will go on to Mr. Kinsella. What is our item here? There he is. Go ahead.
No questions.
All right. Mr. Latham, as soon as I find you. There you go. Go ahead.
All right. Well, so this counterfactual question, the idea, I mean, and if you can disclose, I'm curious how many affiliates the Reconciliation Committee was dealing with.
12.
12. So did we end up with ballot access on 47 states?
47 states. Actually, well, yeah. So 12 plus I worked with members of the GOP in Illinois to withdraw the nomination papers there, and they ran into some procedural hiccups there. So Tennessee was one that had said that they were not going to endorse him, but they were also going to not fight against getting him on the ballot. So I would say that we won that, but then it ended up not happening because they didn't get enough signatures.
Okay, so then just this kind of feeds into the question I asked Mr. Sarwark, just this issue of full support.
What?
Had you pushed things early before the Reconciliation Committee had done its work, I mean, do you have an estimate of ultimately how many ballots our candidate would have ended up on?
I think we would have missed one or two. Let me think about how to phrase this. The situation is that a handful of state affiliates, more than a handful, felt that if one or two people or one or two affiliates didn't put him on the ballot, then it would be an opportunity for everybody who strongly disagreed with and disliked the campaign to save face and be like, hey, look, we were forced to put him on because of our bylaws, but those guys, they didn't have the same bylaws thing and they got away with it. And we really wanted to do that. We just couldn't. So that was a sentiment that was brewing in many state affiliates.
Okay, so just then I think my question again that I put to Mr. Sarwark was the idea that it sounds like by instructing and directing Ms. Harlos to wait on the Colorado paperwork, you were trying to maximize ballot access across the country.
Yes. So charging headlong into a battle, especially if I did it, I think would have popped off a reactionary behavior where people were like, well, this is the battle cry. You're not going to tell me to do that. That's not what I'm going to do. Like, you can't tell me what to do. And, Colorado was definitely pretty defiant. And that's their spirit. They talk about it all the time. But I had a really good dialogue going with them. And, the reality is that I convinced them. How was Ms. Harless even able to make this happen? Because I convinced the LPCO not to put Kennedy on the ballot the day after they passed their motion. That's the only way that she was even able to get it through, is I was like, hey, can you guys just wait a little bit? What if something happens with him? What if you can't get him on the ballot? What if you screw it up for him? What if he drops out? And then they were like, yeah, you're right. We're going to wait a little while. That was how that worked out.
Okay. Your answer is making me think of a question that's relevant to this appeal, probably relevant to the other one. If you don't feel that you can answer, I'm going to just respect that decision there. But so a question that's coming up, there is this corporate knowledge rule that officers have to share information. And one could read the LNC's response in this one about we had to keep things secret. And one can read that Ms. Harless was kind of in the dark. So she didn't really know what the LNC was up to in this dealing with Colorado. So she kind of acted the way she did based on incomplete knowledge. I mean, can you shed some light on that? Is that a fair way to be looking at that? Or, again, I'll respect if you just feel like you can't talk about that right now.
I can talk about it. I mean, I'd say it's completely the reverse, that she was kept in the loop. She was on the Reconciliation Committee where we were discussing it when she found out Colorado was not going to be on. And there was a disgruntled member in Colorado who was like, I think Angela's in on it, that she resigned in a huff and was like, Colorado kept me out of the loop. I think the chair kept me out of the loop. She was in all the communications. I believe she was also in a group chat with them where they were discussing it. In fact, she's the one that tipped me off. I was afraid people were going to start trying to put Donald Trump on the ballot, not Kennedy. And so when she mentioned the Kennedy concern to me, I sort of dismissed it out of hand. This is, way prior, and was like, don't worry about it. And if people are upset, and I know some of them are, I'll talk to them. So she had a little bit more prior knowledge than I did. She filled me in. I was initially dismissive of it, and then we took it seriously. And then when it comes to, secret knowledge, she decided she was going to file this form. She notified Ms. Yanuskavich, and it's explicitly said, do not tell the chair. Ms. Yanuskavich blew the whistle and let me know anyway, and I made the calculated decision to, well, I'm trying to solve the conflict here, but I'm not trying to literally keep our candidate off the ballot. So I'm going to have to just let her do it and deal with the aftermath. Here we are.
Okay, thank you. And then I asked this of Mr. Sarwark, just in terms of measuring support, I asked, would not the number of ballots on which our national ticket appeared be one way to measure the fulsomeness of that support? Yay, nay. I'll maybe ask you, are there other measures we might look to in the future? Like some people might say, hey, if we're on 10 ballots, but we got more votes, that's okay too. I don't know. You probably have had discussions about this. How do we measure full support?
Yeah, I think that it's totally, arbitrary and difficult, but like things can come into gray areas. Sandbagging him, if there was like a secret dossier that showed up that I was like, keep Chase off as many ballots as possible, that would not be full support. But I've also identified and listed a ton of the ways that we've been supportive of the campaign, meeting with them every other week in the beginning of their campaign, holding a fundraiser for them. I did some of the marketing for that fundraiser, having staff create social graphics and memes for the campaign, getting the assets from the campaign since they weren't quick to get them out, and distributing them to people who would work with state affiliates, the colors, the branding, headshots, being like, by the way, the headshots of Mike Termott are all blurry or in shadow. I need new ones. All kinds of stuff, passing over all of my interview requests from the media just straight to the campaign. When the campaign was too slow, I started passing them straight to Mike Termott because he was willing to pick up the phone and talk to me, directly. So I think that we did give them full support, spending $55,000 to regain ballot access in New Mexico, which unfortunately doesn't seem like it worked out. But we put in the effort. LNC members going there themselves personally. I'd say the phrase "as soon as possible and without delay." That's not in the bylaws. A lot of this has to do with judgment and discretion.
Okay, thank you. Question I asked Mr. Sarwark, I'll ask you. So what is the LNC's, I guess, view of which standard governs here on suspension or removal? Is it the for-cause standard as stated in the bylaws, or is it this failure to perform the duties or gross malfeasance? And I guess since it was brought up, there's the Roberts standard that's kind of in the middle. And I'll ask you this question just because I do want to put the same thing to Mr. Jacobs, because I believe he has submitted an amicus saying that it's the for-cause standard, or that I guess imports Roberts as well. So what's the LNC's position on what standard we should be looking at?
Yeah, I think it's for cause, but I think you look to the bylaws and RONAR. We've relied on opinions by Mr. Jonathan Jacobs, in addition to some other parliamentarians. So I'm happy to have him weigh in on that.
If I may, yes. Basically, I'm not going to be the only one to weigh in on this, because your past Judicial Committee weighed in on this. And they said that it was the standard of cause as interpreted by RONR. The person who wrote that opinion is currently Ms. Harlos's counsel. I happen to agree with it at the time. The opinion, I believe, was also expressed by Mr. Brown, the current parliamentarian. I was serving as her parliamentary advisor. And I said, and she incorporated this into her case in chief, that was the standard.
Can I interrupt you there, Mr. Jacobs? And just so a response I've already heard to that argument is that the policy manual is new and has therefore superseded that standard. So what's your response to that argument?
Well, I'm going to start with some, I'm sure, very butchered Latin. Expressio unius et exclusio alternus. It's a legal maxim. I'm sorry if I've really butchered that.
You've upset at least 2 members of our committee who apparently really don't like law stuff, but you've got 3 of us who are okay with it.
Okay, thank you. Basically, there is a provision in Robert that says, and I can get it for you, that says the expression of one thing in the bylaws is the exclusion of like things.
Okay, and you've put that in your amicus, I believe, if I'm not
Yes,
mistaken.
it's going to be in a future amicus as well.
Okay.
In great detail, and yeah, so I would say very definitely the cause is binding, and that a lesser rule cannot limit the cause.
And I think I heard Mr. Sarwark say that the LNC can narrow the standard. Would you call this failure to perform the duties or gross malfeasance that's in the policy manual? Is that a lesser standard or a greater standard or higher standard?
I believe it would be a higher standard.
I agree.
It would be something that could not, in my view, be enforced.
Well,
Now,
I guess it's all depends on your perspective, right? Because I think we've been getting into this. It's one's perception when you say lesser or higher.
Okay.
It's going to be
greater
more
threshold.
difficult for the officer to violate
Yes.
the failure to perform duties or gross malfeasance. It's going to be easy to violate the for-cause standard, right?
I think that's correct.
Yes.
Okay. Yeah, this higher, lower, lesser, greater.
Okay.
We're going all over the place on that one. It depends on where you're looking at it from, I guess. I really think that's actually all I have, Mr. Chairman Pro Tem.
Thank you, Mr. Lisa. We move on to Mr. Parnov.
Okay, I basically just have the same questions that I had before. Well, I guess except for this additional one, is it your position that provision in the policy manual of gross malfeasance or failure to execute the duties of office, that is null and void because it's in violation of the bylaws?
Are you asking me?
I'm asking Ms. McArdle. She can send it over to you.
I'll kick it over to Mr. Jacobs, but I allege that we did meet the threshold of gross malfeasance.
I think even if you did not meet the threshold of gross malfeasance, it is void to the extent that you can charge somebody specifically for the charges of misconduct that were previously agreed to by this committee. And
that provision is in violation of the bylaws, in your opinion.
In my opinion, that and some other things in that section are violations of the bylaws. Yes.
Okay. Now the strategy. It seemed like there was a very delicate negotiation between Ms. McArdle and Colorado.
Yes.
And I understand Karen Ann presumably jumped the gun on it, right?
Correct.
And put the whole negotiation in jeopardy.
Yes.
Was this policy that she violated? Did she do anything that violated a vote or decision of the executive committee or reconciliation committee?
I'd say it was a violation of the reconciliation committee that I put together, yes. And the LNC did not vote on the reconciliation committee, but they certainly could have voted to rescind it if they disliked it.
Did the reconciliation committee vote on it?
No, we did not. We did not take an internal vote on internal policies.
So the allegation is just that Ms. Harlow's violated your personal instructions, not the instructions of the Reconciliation Committee or the Executive Committee or the LNC.
I don't think that's quite correct. You know, I made you know, an ad hoc committee, and it became part of the LNC's policy. If that makes sense. Like it was a decision that I made as chair, but it wasn't an opinion. I was like, you know, this is what I'm doing as chair. We're putting together an ad hoc committee. This is the purpose of the committee, and this is what it's doing. And there were committee members, and they were like, okay, we agree with this. We're going to go ahead and execute the duties of the committee, and no one noticed it to rescind it. But
was Karen on? Well, I mean, was Ms. Harless on the
yes, she
on
was.
this ad hoc committee?
Yes, she was. And she did move or attempt to
So
move.
she was aware of the
yeah, absolutely. And she noticed a few times, you know, to reverse my decisions on various things, or to, you know, instruct the chair or the chair's attorney to try to do X, Y, and Z. So she could have also done that with the Reconciliation Committee. Anyone could have if they disagreed with the strategy. Why was there nothing in the allegations that indicated gross malfeasance? I didn't see anything in the I didn't see like gross malfeasance specifically charged or specified. We gave really specific allegations and charges, and they were pulled straight out of Ronar, to my knowledge. Mr. Jacobs, do you have any additional comments on that?
No, I think I think the first one could certainly encompass gross malfeasance.
Absolutely. That's my
yeah. I think that the second one is a little bit different, but that also, you know, it depends on what you consider gross malfeasance. One of the specifications is effectively saying that she tried to obstruct the LNC by giving incorrect information. Is that gross malfeasance? I would tend to think so. Somebody could disagree.
But you feel it was gross malfeasance for her to violate the dictates of the ad hoc committee? You think that there was some kind of malicious intent on her part?
Yes, I do.
To do that in violating. Is it possible for you to elaborate on that, or is that too sensitive for public consumption?
I mean, I think I touched on this in my opening statement. I think that the point of her actions, you know, culminating in where we're at now, and eventually her lawsuit, even though that's not under the jurisdiction of this hearing, it was not about supporting the presidential ticket or preventing what she perceived to be a gross injustice from being done. I think the whole situation was spun up to create a public spectacle of hero worship and martyrdom. And I think that unfortunately, that's her custom and practice. And, you know, it would behoove me to make better decisions regarding the company I keep and the people that I endorse in the future. We've seen this happen in the past. You know, most of us experienced it to some degree, and we were on different sides of it. You know, and I think that that's what's happening again, and I think it's very unfortunate. But I think that that is really what this comes down to, that it's not about Chase, it is about the secretary.
All right, and the last thing is something that I forgot to ask Mr. Sarwark, but maybe you can answer it. There seems to be an implication that the remedy for decisions made in an unauthorized executive session is that those decisions are null and void. Is there any, I know I'm asking the wrong side here, but is there any citation for that? Is there any
tell me what you mean by decisions?
That can be specified that would indicate that's the case?
Can you tell me what you mean by decisions? Because we don't vote on things in executive session. We discuss things, but we don't vote on them. All votes
are taken in executive session?
What's that?
We don't
No
vote on
votes are
anything.
taken.
Not a single, nope. We don't count heads. I don't say, okay, confidentially, I want a show of hands. We don't do that. You discuss it and you know, decide in your head and you go out and you sometimes have to take a gamble if you can't read the room and take a vote. But no, not a single official vote or I guess you could say official decision, not an official decision is made in executive session. Discussion only.
I see. Discussion only. Well, I know Mr. Sarwark spoke of actions. I don't know.
And perhaps
I'm
he
not
did
sure
things
what an
differently.
action is exactly, but he said actions would include discussion.
Nah,
Is there any
I strongly disagree. I think that's a
anywhere in Roberts or anywhere that votes taken as a result of discussions that improperly took place in executive session would have to be overturned?
That's quite a stretch. Mr. Jacobs, do you have anything to add to that? I'm like trying to think of a citation to a thing that, you know, like I can't refute a negative.
Yeah. There would have to be something in there where an executive session would be done in violation of somebody's rights. And there wasn't anything done in violation of somebody's rights in this. You would a main motion, and I'm trying to find the actual definition of it here, is basically what takes action. And there were no motions in the meetings, at least that I was privileged to be sitting in. So no, there would be nothing in there that was, there would be no kind of derivative thing or fruit from a poison tree or something such as that with an executive session, unless you could show that the executive session violated somebody's rights. And I do not believe that it did. I believe that they were proper.
Okay, well, my apologies for asking you a question asking you to speak against your own interest. I don't know if Mr. Sarwark is still around. If he could answer that, if the committee would indulge that. This is the last question that I have. Okay, I'll have to deal with that without an answer, I guess. Thank you. I'm done.
All right, thank you, Mr. Chernoff. Next up is myself. For Mr. McArdle, is the investigatory committee still in formation?
No, I don't believe so. I believe it was convened through the end of the investigation and trial.
Okay, so when was the end of the investigation?
Do you wish me to answer that?
Sure.
Okay. When the investigating committee reported and made its report, which was on 10/6/24.
So at that point, then, once they presented their report, they were discharged?
Yes. Yes. They could be conceivably reconvened, but I don't know of any attempt to reconvene them.
All right. So in relation to that, during that 10/6 meeting, the investigatory committee presented the report, at which point they were discharged from their duty. And then I believe, and please tell me if this is correct, was the motion to suspend from duty made after the report was presented?
No, there was no motion to suspend their duties. There was just the committee. It was a special committee and it is suspended when it reports.
Is suspended the right term or almost like dissolved?
It would be, yeah. Yeah. Let me see if I can find the actual language here. Let's see. Let's see. See, I think it would be 1050. A special committee may, let's see, which falls under this. Yes, here it is. A special committee is a committee appointed as the need arises to carry out a specific task, and at the completion of which, that is the presentation of its final report to the assembly, it automatically ceases to exist. My apologies for the delay.
Okay, thank you, but that's not what I'm asking. What I'm asking, and let me rephrase it a little better, was once the committee presented the report to the LNC, subsequently there was a motion made to suspend from rights and duties and membership the secretary. Is it correct to say that motion happened after the report was presented?
Yes, it was in the report.
All right. The policy manual specifically says on this specific case that the officer at large's membership rights can be suspended by a 2/3 vote while the matter is being investigated if necessary to prevent potential harm to the party. So if the secretary could be suspended while the investigation was ongoing, how can she be suspended once the investigation is completed?
The
timing
motion,
is wrong.
May I answer that?
the hearing wasn't finished yet. With the IC, nothing was adjourned, but sure, go ahead.
May I? Thank you. She was suspended under the provision of RONR, which deals with disciplinary action. You can suspend once you have charged somebody. That particular rule in the policy manual says it's kind of like the police picking you up without actually charging you. And it's saying that until such time as we get around to investigating you, we're going to suspend you. I have questions as to whether or not that rule violates the bylaws or not. I actually think it does.
So, but the policy manual overrides Roberts.
But it doesn't override the
Very
bylaw.
clearly.
It doesn't override the bylaw, and it would not prevent the Robert action from taking place.
But if you're claiming that the bylaw overrides the policy manual, then by extension, you're saying suspension from duty, if failed to appeal, would lead to an automatic removal.
I would not say that.
What the history and the wording of what Article 6, Section 7 actually says. So that doesn't make any sense to me.
Okay, well, as I said, I think the rule itself is a violation of the bylaws. I think that there can be a temporary suspension pending a trial after charges are adopted. I would, let's see if I can phrase this properly.
And that's what we did.
Yes. This would be something similar to somebody being arrested and taken to jail. The first rule is we're going to arrest you, but we're not going to charge you pending a trial. And that's where I think there is a problem with due process. And I think that there is a problem with that rule. I would also note, if you take a look at my amicus brief, I said that the charges would not be subject to appeal by a small group of members by going through the process that Dr. Phillies did. I did not say that about suspending someone using that rule. I think that if a future LNC would choose to suspend somebody, put them on trial 9 months from now, and keep that suspension in there, that it would be possible to appeal that suspension. I think the reason that suspension could not be appealed now is because it is over. And I do hope that no future LNC would be stupid enough to try to do something like that.
All right, I am completed with my questions. We move on to Mr. Krawchuk.
Thank you very much. Again, most of my questions have been answered. I'm only down to a couple. Angela, did you sign the Colorado submission?
The certificate of nomination, yes, I did. I signed 2 of them.
Okay. And with the secretary submitting them, isn't that considered full support, as Nick was laying it out?
With the secretary submitting them?
Yeah.
Yeah, I mean, I'd say that she's not supposed to submit them, staff is. And we all know that and discussed it. But certainly, I mean, that was part of full support.
Okay.
I signed it. I signed 2 of them.
Okay. Now, when you say staff is going to submit, is that the regular process that like in the policy manual, or is that just tradition?
There's no policy manual on this. There's no employment guide on it. Our former operations director and I think occasionally executive director handled this, and there was 0 documentation passed to us on it.
Okay.
So what I had to have staff do, and by the way, there was a big heated dispute that our secretary was involved in regarding whether or not we were going to give them to the state chairs, to the SOS. So who were we going to give them to? Because we didn't want our candidates to end up on the ballot for the Liberal Party or splinter groups in a handful of states. So the procedure we decided on, and staff had to keep meticulous track of it on a spreadsheet, that I also saw was staff has 2 copies. They send the first copy to the state chair, and we work with the state chair to make sure it is submitted. And another reason we did this is because a lot of the state chairs were new. There was no documentation for us to rely on, and not all of the states would accept the certificate paper that we had signed. Some states have very particular ones, and we didn't know which were which. There was something very particular in Ohio and Arizona that had to be done that delayed the paperwork process, by the way, and that was on the campaign's end, not our end. So I saw a few things happen that were procedurally wonky, if that makes sense.
Yes. Okay. And let me hit you with the question that I asked Nick. What was the time delay between when you asked Karen Ann to hold off for a while and the deadline for submission?
Nearly 2 months.
Nearly 2 months.
Nearly 2 months. I believe when she submitted it was around July 8th. It was close to the time that we were going to be in Freedom Fest, which was also a huge headache because we were there to fundraise and do all kinds of stuff. And then it was due, I believe, September 6th, somewhere around that time, the end of the first week of September.
Okay. So really the big question here is, should Karen Ann have submitted that when you told her not to?
Yeah, and my contention is no, not should she have ever submitted it. Technically, staff should submit it, but should someone submit it prior to September 6th? Yes.
Absolutely.
And I would have given different instructions if I knew that submission by LPCO with a different candidate was imminent. But that was not the situation, and that had a lot to do with the instructions I gave.
And if it were imminent, I gather you would have supported it?
Yeah, but I probably would have had someone else do it to take all of this intensity and social media drama out of the situation. I would have had a staff member do it. I would have had someone else do it, an attorney do it, something to not have this outcome.
Okay. So what I'm hearing is that this delay that Mr. Sarwark is talking about is just not really a big deal.
It's not a thing. It's not a thing. There, California had a delay as well because the Secretary of State there gave the state chair terrible instructions. And I worked with him. He got that stuff submitted within 48 hours. And they came back with him with this crazy thing about electors and how it's got to be like 50% female or something. And, the campaign was sort of panicking and they're like, why didn't you submit it? And I'm like, I literally am copied on the emails to the Secretary of State. I saw Adrian Malagon submit it, and there was all this drama, but it didn't hurt him in the state of California. All of the libertarians there, and he'd been campaigning there, they were told and they knew he's going to be on the ballot there. It's
Right.
explicit in their bylaws. He's like, there's no rumors that they're not going to put him on. Like, they're just going to always be administrative hiccups when you do something in
Yep.
50 states with different personnel changeovers and different state laws.
Yep, I would agree. Some kind of submission like that typically is just an excuse for a press release, but everybody already
Yes.
knows he's the candidate.
Yes. And I would say, and I worked with the campaign, pretty closely. I was speaking with Steve Dossbach or someone else pretty much every day to give them updates on this situation. If they had asked me, how do we handle it because it's not in yet, my advice would have been send the press release anyway.
Yeah.
Because he's going to be on the ballot.
Yeah.
You don't have to include like this boring little screenshot of something on, the SOS website. He's on. If you want a quote from me, I'll give it to you. Like, there was no withholding of that kind of support.
Right. Understood. Okay. let me just go through my notes here one more time. I think that is going to be all. I guess I had, excuse me a moment longer. No, it looks like, oh, just a question. Is Karen Ann suspended or not?
Yes, she is suspended right now. That's obviously pending whatever happens with her JC hearing.
Okay. All right. That is it. Thank you very much. I
Thank you.
appreciate it.
All right, we are going to move to rebuttal. One moment, please. While we get everything lined up correctly. Let's see here now. All right, we have 5 minutes of rebuttal by the appellant. Either Dr. Phillies or Mr. Sarwark, go ahead. Should be unmuted.
Oh, I can do it now. Wild. It's been a lot of questions, so it's a little tricky to know which ones to cover in rebuttal. The LNC side has relied on procedural correctness. We followed this provision of Robert's Rules of Order newly revised, or they've also pitched the idea that because this is already done, somehow it's all mooted out and it's all water under the bridge. At one point, Mr. Jacobs said, I think that the bylaws are actually violated by the pre-investigation suspension in the policy manual, kind of confessing the fact that everything's wacky here, but then backs away from it and says, well, I hope no future LNC would be that foolish as to do something. The response of the LNC, especially Ms. McArdle, has confirmed that there was no vote anywhere. There was no vote to create a reconciliation committee. She did it by herself as an ad hoc committee by fiat. She made the decisions about what the committee was going to do without there being any vote on the committee. She made the decisions all along without there being anything to review, and alleges that somehow because nobody tried to stop her, nobody voted to rescind this ad hoc committee that was just a group of people that she picked, that somehow that's approval. That means the LNC supported her authority to say, just hold on and slow roll this paperwork that has already been signed. Don't send it to the Secretary of State. This idea that staff is responsible for submitting the nomination papers is false. It's just not true. It is a secretarial duty. It was a secretarial duty in 2012 when Alicia Matson did it. It was a secretarial duty in 2016. It was a secretarial duty in 2020. The fact that this LNC doesn't have the institutional knowledge to know that it's the secretary that does it or directs staff to do it is unfortunate, but this idea that staff has to do it and we didn't know what we were doing is an entirely self-inflicted wound. The secretary has an obligation to do the job that is required by the bylaws. That's what we come back around to here. The bylaws require the secretary to submit the nomination paperwork to provide full support to the candidate. And these characterizations from the other side, they would like to say that this isn't a problem. It's all water under the bridge. It's all behind us now. No one should worry about it. Everything worked out. But it didn't work out. Tennessee specifically didn't make the ballot in spite of it being a very low signature threshold because of this delay, because of all the time taken, because of the coddling of state affiliates doing things that violated the bylaws by a chair who thought that it was a good idea for the strategy that she chose herself to pursue on her own bump. It's just nonsense on stilts. And what this really comes down to is, do you believe that the bylaws matter? Or can any LNC chair, any group of a majority of the LNC decide that the purpose of the party is something different from what it says in black and white? And if you allow that to happen at that point, we become a lawless organization. We no longer follow our own rules. And that would be unfortunate for the Libertarian Party to do that. We have always prided ourselves on following our own internal rules. And so I would ask you to cut through some of the obfuscation here. Look at the facts. There was a request by the national chair to delay putting the candidate nominated by the national convention on the ballot in various states to the detriment of the campaign. And the secretary did her job in spite of being told to delay doing her job. She did the job she knew how to do from having previously done the job in another cycle. She knows what she's doing.
Mr. Sarwark, we are up at time. We're up at time.
Thank you.
And Ms. McArdle, 5 minutes of rebuttal.
Thank you. The phrase "as soon as possible and without delay" is not in the bylaws. The phrase is made up. There is no way to correlate sending in paperwork a few weeks later with a poor showing in the general election. That is completely unsubstantiated. When we say delay, we are not talking about a delay in getting ballots out to voters for the general election. We are talking about a chunk of time within a 3-month timeline to get paperwork into an administrative office. There were 2 months left. Hypothetical situations about what would happen if Kennedy had made it onto the ballot in Colorado are not real situations, and they should not be part of the deliberations of this body. I convinced the LPCO, along with many other states, and thankfully, with the help of the Reconciliation Committee, not to put RFK Jr. on the ballot after they passed their motion. There was a delay in getting the candidates' nomination papers into Arizona and Ohio as well, but that was due to the campaign. There was no push to keep Chase off the ballot by the LNC. When Ms. Yanuskavich alerted me to Karen Ann Harless's actions, I could have called LPCO to tip them off, but I did not. A person skilled in diplomacy can persuade someone who dislikes the POTUS to cooperate and put them on. I did it with the help of Pat Ford, Kathy Yanuskavich, and Andrew Watkins. The LNC did have an official policy. We had a reconciliation committee, and we were working with multiple state affiliates, including LPCO. We did take a calculus, and we did it with good reason. Disaffiliation in New Mexico was an expensive debacle in my first term. It cost us $55,000 to seek ballot access, which we did not retain. It was a tremendous amount of work to reconstitute our affiliate, and we did not want to repeat that in Colorado, knowing that they were ready to fight in the legal arena and they had legal counsel backing them up already. Mr. Redpath went to petition in Tennessee, and he said it was the hardest petitioning work he had ever done. It was harder than DC. That had nothing to do with nomination paperwork or not receiving full support, since our treasurer was there on the ground. Filing paperwork was not the secretary's job. That's untrue. It was staff's job. The chair directs the executive director and staff. The secretary is not the person who submit the forms. It is not in the bylaws. She is not the person who mailed in 50 certificates of nomination in 2020. I read the paragraph-long description of the secretary's job. It doesn't include submitting paperwork, and I worked with her to scramble and try to figure out what to do this election cycle because she had no idea, because Robert Kraus had always done it for her. We both signed certificates of nomination. However, I signed all 50 of them twice, and potential litigation certainly falls under the litigation exception. There were cease and desist letters sent. Our bylaws say pending or potential litigation. It is right there in the bylaws when it comes to executive session exceptions. Thank you so much.
Absolutely, I'm muting myself. We are now on to closing arguments. So we will have the appellants for 10 minutes in 1 moment. All righty, Mr. Sarwark, go ahead.
First, I'm going to ask if Dr. Phillies has any things that he would like to add in closing that I may have forgotten while I was taking notes on the argument.
The only point I would like to make, which I think has been made before, is to make entirely clear that we are appealing decisions that were made by the LNC on October 6, which did not include suspension for removal. It's a shame that suspension is used with two different meanings. Suspension for removal of the national secretary. We are appealing a series of decisions that were made by the LNC, the core of which is specification 2 of charge 1. And having argued that that specification is invalid, the remaining specifications and charges and consequent motions are the poisonous fruit of a rotten tree. But I'll now let Nick explain this in more detail.
Thank you. We're here because there is a division inside the Libertarian Party. The National Committee is controlled by a group of people who primarily wanted a different candidate to be nominated at the National Convention in Washington, D.C. There were attempts made well in advance of the convention to try and tilt the odds in the favor of the preferred candidate of the chair and others who side with her on her faction. It didn't happen. They lost at the National Convention. Chase Oliver was nominated by all of the delegates. But rather than figure out why and move forward according to the bylaws, the national chair has fought a rearguard action with other state affiliates, with other candidates from other political parties. She has cut deals with Republicans. She has cut deals with RFK. She has cut deals with various state parties. Karen Ann Harlos did something that was right. And that is always a tough phrase for me to say. She submitted the nomination paperwork as required by the bylaws. In the absence of an experienced executive director and in the presence of an attempt to delay to allow further uncertainty to bubble, to allow more opportunity for maneuver by the Colorado Party, done in an ad hoc committee with no votes. There was no official policy ever adopted anywhere by a vote of the LNC. This was entirely the chair acting on her own strategic instincts and her own, as she said, judgment. She decided that it would be better for a reconciliation committee to happen to give some credence to all of these state parties that wanted to violate their own duty under the bylaws. She is the one who decided that she was going to engage in protracted talks with Tennessee. And then when Tennessee decided that they weren't going to submit someone else, that was good enough, even though the complete and utter lack of support from Tennessee was part of the reason that that petition drive failed. She decided to engage in a fight that caused the disaffiliation. She decided to spend $55,000 to try and reaffiliate New Mexico. She's made all of these decisions herself. And the chair gets to make a lot of decisions themselves, I should know. But they cannot make decisions that are in violation of the clear, plain language of the bylaws. They cannot order or ask for another officer who has a bylaws duty to provide full support for the candidate to stop doing that, to not do that, to hold back, to thwart the candidate, to delay the candidate, to provide more opportunities for either RFK or Donald Trump to get more votes, to protect Donald Trump from the fate that he suffered at the hands of Joe Jorgensen in 2020, where he believes that our candidate was the reason why he didn't win. That is what's going on here. And it's a problem when a chair has a dissenter who wants to follow the rules, who wants us to follow our bylaws, who won't shut up about it, who won't stop blowing the whistle, who is super annoying. It's a problem. But the right way to solve that problem is to do things by the book. to have a real reason that meets the definition that's required to suspend somebody. It is not to trump up charges against someone for doing their job, to have an investigatory report in secret that no one can review, to keep somebody out of the position that they have been elected to by the delegates through these procedural maneuvers that violate, as Jonathan Jacobs has said, due process. Sorry, I misstated. These maneuvers are intended to get rid of a problem. Will no one rid us of this meddlesome secretary? And you have an opportunity as a judicial committee. You can either follow the plain rules of the bylaws. You can acknowledge that telling somebody to not submit the candidate who was nominated at convention is an absolute request to violate them, and that the right thing to do, the only thing to do when you're giving an illegal order, is to disobey it. That's a principle that goes well beyond our rules. That's a principle of law. That's a principle of common sense. That's a principle of right and justness. You have to do the things that are required by the rules. Otherwise, we have chaos. We have, I'm in charge. If the president does it, it's not illegal. That is the standard that we have been given in our country by the Supreme Court for the president the president-elect. But that's not the standard that we have to take within the Libertarian Party. The Libertarian National Committee and the Libertarian Party is better than that. We follow our rules. We do what's right. We solve our problems internally. And at the end of the day, sometimes you're on the winning side and sometimes you're on the losing side, but you don't cheat. This is an attempt to cheat. And the members have been cheated by this violation of due process. The members who voted for the nominee have been cheated by this attempt to punish someone for doing the job that they were elected to do. And so with that, I would ask you to read carefully all of the submissions, read carefully the bylaws. And if you can't say with confidence that what was done is full support, that what Angela McArdle asked for is full support, that what the Colorado affiliate wanted to do is full support, then what they're asking for is not full support. What they asked Karen Ann for was not full support. She did the right thing here, and she's being punished for doing it. It's wrong. And you can either approve it or you can rubber stamp it. You know, you can let it go if you want. You can ignore the appeal. You can decide that you don't like me or Dr. Phillies. That's fine. But the evidence is there. The rules are there. It's in black and white. It's written in English. There's 50 plus years of history of exactly what a national committee, a chair, a secretary are supposed to do when there's a nomination for president. It was not what Angela McArdle asked Karen Ann Harlos to do, and she did what was right instead of what she was told.
All right, thank you, Mr. Sarwark. One moment. And unmuting people. All right, we have, there it is. All right, closing arguments for the LNC, Ms. McArdle for 10 minutes.
Thank you. The decisions and actions of the LNC that are the subject of this JC appeal were carried out correctly under the scope of the LNC's bylaws and RONAR. The removal procedure is governed by bylaws 6.7, Policy Manual 101.4, and RONAR 63. That is what we followed. This is not a trial about the Supreme Court or Karen Ann Harlos's trial. It is an appeal about the votes of the LNC on October 6th. Mr. Phillies argues that punishing a National Committee member for executing duties required by the bylaws of the LP is contrary to those bylaws. Therefore, all 8 motions that were passed based on that conduct must be voided. His argument is incorrect. There is no time frame specified with respect to full support. Full support has nothing to do with how quickly you submit paperwork that has a 3-month deadline. I believe Mr. Phillies has failed to properly establish that the former secretary was actually acting within the scope of her duties in the first place, and he only contested 2 of the 8 resolutions adopted, yet he contends all 8 should be found null and void on that basis. I believe his JC appeal, respectfully, is woefully inadequate. I will turn over the rest of my time to Mr. Jonathan Jacobs.
Thank you, Madam Chairman. Thank you, Judicial Committee. I wanted to start off by saying one thing here, something that everybody seems to have missed. You had a member of this committee the last time by the name of D. Frank Robinson. He wrote the bylaws. Mr. Robinson has said publicly that a state affiliate could conceivably not field a candidate, and that would not constitute a violation of full support. Ms. McArdle's actions helped prevent that. That was a good thing for the party. It would have been under the bylaws, would be permissible, but it did not happen. Somebody should say that, and I guess it's going to end up being me. The second thing is, you've talked about some of her actions here. You know what? She isn't taking those actions individually. She has a board that can overrule her, which is fine. I've been in situations where boards overrule me, including boards I've appointed. It's not a bad thing. But if there was some problem, it would be up to that board to override her and to reverse her actions. Ms. Harlos had the ability in this particular case to go to her fellow LNC members and ask for that decision to delay this action to be overturned. She did not do that. That would have been in order. But she chose not to do it. Just on one point in Mr. Sarwark's argument, I've said that the rule in the policy manual relating to delays, in my view, or relating to suspension before a hearing is out of order. Or would not, excuse me, not just out of order, but a violation of the bylaws. Because RONR says if you're going to put something like that in there, you would either have to put it in the bylaws or do it through disciplinary action. And that does not do it through disciplinary action. A disciplinary suspension, which is a little bit different, is something that you can do because it is a disciplinary suspension. The disciplinary, let's see, the LNC does have the ability to choose to discipline and to choose not to discipline. I would note that one of the charges that was not adopted by the LNC, one of the specifications actually, was that the action taken by Ms. Harlos violated the autonomy of the Colorado party because it deprived them of the possibility to choose no candidate. That's all that I have. Thank you.
Ms. McArdle, anything further?
I believe we're finished. I will mention that a copy of the investigative committee report was submitted to you all confidentially prior to the hearing. That's all. Thank you.
All right, at this point, we are concluded with the hearing. It is 6:19 p.m. Central Time. We will stop the recording now, and we are adjourned.